Let's now turn our attention to capital punishment. In the United States, capital punishment has gone through various phases. Popular opinion may be that we've always executed a lot of criminals, and it's only been recently that we've backed off some. Well, that's not true. We've had ebbs and flows throughout our history. Um, the period when we saw the most executions was really after the Civil War and leading um, up to World War II, and we saw a peak of executions during that time period. When we had an important period at the end of the 1960s and leading into the 1970s when it appeared that maybe capital punishment was on its way out. As you can see in this slide, there were no executions from 1967 until 1972 and actually until 1978. And we'll explain why those dates are important. But by the end of the 1960s, it seemed as if society wasn't willing to execute anymore. That maybe the death penalty had run its course and it was time to get rid of it. Most other countries in the world had done that already. European nations had abolished the death penalty, and the U.S. even in the 1960s was pretty much standing alone. We're even more alone today in having the death penalty. But in 1972, even though it appeared that the death penalty was on its way out, there were other contraindications that seemed to say maybe not yet. After all the unrest due to protests in the 1960s and the counterculture, the hippie culture, and everything else, President Nixon won on a campaign of law and order, that he believed there was, quote, a silent majority out there that really wanted to return to old fashioned traditional values and to be tough on criminals again. He may have been right because states, again, tried in the early 1970s, sought again to carry out executions after a period when executions had largely disappeared. And so there were challenges brought to the U.S. Supreme Court, and the most important of these was Furman versus Georgia. In Furman versus Georgia, Furman claimed that the death penalty that he received was arbitrary and therefore cruel and unusual. Why did he consider it arbitrary? Because the procedures that were used didn't really give the jury much guidance. What happened in America before Furman versus Georgia was a jury would hear a trial, as you know we see on TV, the typical kind of trial that you think of to determine whether the defendant was guilty of a capital offense or not. Are they guilty of murder, perhaps even rape during this time? Are they guilty of those charges? If they found that the person was guilty, at the same time they were deliberating whether the person was guilty or not, they would then move on in that same deliberation without any additional hearings. They would then decide whether this person deserved death or not. If they decided that the person deserved death, they would recommend that sentence to the judge, and the judge would confirm it then. Well, there was really nothing in those procedures to tell the jury what they should consider when they were determining whether the person should get a death sentence or not. Why does one person deserve death and another person get life? And so Furman said this was too arbitrary. They might have been considering things that they should have never considered, like race and class and things like that, rather than the facts of the case. So Furman argued the death penalty should be struck down. A divided court agreed with him. It's important to note, though, they declared it unconstitutional as administered. What that means is that they said, under these procedures that I've just described, any death sentence that's returned under these procedures, that death sentence is unconstitutional. The Supreme Court as a whole was not willing to say the death penalty is done. There are no circumstances that justify the death penalty. That would be declaring the death penalty unconstitutional per se, meaning in all situations, in all cases. The court did not do that. There were some justices who wanted to do that, but the majority of the court did not. The majority of the court said, under these practices, so as administered, the death penalty was unconstitutional. Well, the states didn't give up. In 1976, They returned to the Supreme Court with new death penalty procedures that they thought were compliant with Furman versus Georgia. There had also been some changes to the Supreme Court. Some anti-death penalty justices had been replaced by pro-death penalty justices. Again, there were new death penalty procedures implemented by the states. And so what were these new procedures? Well, the new procedures resulted in or required a bifurcated trial. What is a bifurcated trial? It's a two-phase trial, a two-part trial. The first phase of a bifurcated trial focuses solely on the guilt of the defendant. Did the defendant actually commit the offense? So this looks like an ordinary regular trial. The jury hears all the evidence, they go back and they deliberate, and they decide whether the person is guilty or not. If they decide the person is guilty of a capital offense, we move on to the second phase. So it's the same jury, but now there's a new round of hearings. At these hearings, we're not trying to re-argue whether the person is guilty or not. We've already determined they're guilty. Here, the sole focus of the jury is what sentence does the person deserve? And instead of just allowing them to decide that without any guidance, we require that the prosecution prove at least one aggravating circumstance beyond a reasonable doubt. Pennsylvania has 18 different aggravating circumstances. The prosecution has to prove at least one of them. They don't have to prove them all, but they have to prove one beyond a reasonable doubt. And so what are examples of aggravating circumstances? Well, torturing the victim, contract killings, being paid to kill someone. The most common aggravating circumstance is killing someone during the course of another felony. So an armed robbery, typically. You're holding up a convenience store and you kill the clerk. So that can be an aggravating circumstance. You're committing another felony. You killed a police officer. Things like this. Again, Pennsylvania has 18 of them. The prosecution has to prove at least one of them beyond a reasonable doubt if they want to get a death verdict. Meanwhile, the defendant is trying to show mitigating circumstances. So these are more open-ended, and it can be evidence such as the defendant played a secondary role in the murder. So the defendant didn't actually pull the trigger or directly encourage it. Maybe the defendant was out in the getaway car, didn't even realize that their criminal partner had a gun, and that their partner intended to kill somebody. So should they be sentenced to death? They're guilty of murder because they're an accomplice, but should they be sentenced to death because they were out in the getaway car and had no knowledge that anyone was going to die in this armed robbery? Maybe they're going to show that they were had borderline intelligence. They weren't mentally retarded. We'll see that's important in another slide in just a couple of minutes, but they weren't, they had borderline intelligence, so maybe they were really could be influenced easily. So maybe that's a mitigating circumstance. Maybe the jury would consider their upbringing. Maybe they were from a really abusive household, whatever it might be. So the jury can consider all kinds of mitigating circumstances. These are circumstances that would justify mercy. After the jury considers any aggravating and mitigating circumstances, the jury has to determine, one, did they find an aggravating circumstance? And they have to indicate which one they found, or multiple ones. There could be many of them. It doesn't just have to be one aggravating circumstance. But they have to indicate what they found, and then why that aggravating circumstance wasn't outweighed by mitigating circumstances. If they go through that procedure and sentence someone to death, the Supreme Court said that's constitutional. So the Supreme Court upheld these procedures. An additional part to these procedures, in addition to the bifurcated trial, is an automatic right to appeal to the highest court in the state. Pennsylvania, that would be the Pennsylvania Supreme Court. So criminal defendants normally don't have this automatic right, but in death penalty cases, they do. So if the jury did mess up something, the trial judge messed up something, this defendant gets an automatic right to appeal to the highest court. Based on these procedures, the Supreme Court said executions could proceed. These procedures made the death penalty constitutional again. After Gregg, it took a couple years before there were any executions, but in 1978, eventually an execution was carried out and more executions followed. But the Supreme Court had to deal with other issues relating to the death penalty. One involved the juries. Because the jury's verdict had to be unanimous, there was a question about, can we allow people to serve on the jury who say that they are opposed to the death penalty, that their opposition is significant enough that they could not give a just verdict for death when it was called for. So if somebody was opposed to the death penalty enough that they would never vote for the death penalty or were very unlikely to vote for the death penalty, then should that person be allowed to be on the jury? Because if the verdict has to be unanimous, this person can tie up the whole jury. If 11 other people want to vote for death because the evidence is overwhelming, and this one juror doesn't want to vote for death because of their personal beliefs about the death penalty, they can cause this whole procedure to result in a mistrial, a hung jury, and we got to start all over again. So the Supreme Court said a valid question that can be asked during voir dire, during the questioning of potential jurors, is, do your views limit you in such a way that you could not vote for the death penalty? You could not carry out your duties. If the person says, my personal views about the death penalty do prevent me from carrying out my duties as a juror, then they won't be allowed to serve on the jury. So that's what a death qualified jury is. A jury where we have people who may be opposed to the death penalty, but in legitimate cases they've testified that they could give a death verdict where they thought it was necessary. The Supreme Court ruled that it was unconstitutional to require mandatory death sentences. So if we had a law that said anyone who's guilty of first-degree murder is automatically sentenced to death, that'll take care of any bias like racial bias or anything else, the Supreme Court said that's unconstitutional. Not every murderer deserves to die. And so therefore each case has to be considered individually, so no mandatory death penalties. The Supreme Court ruled that the death penalty is inappropriate for rape. Throughout most of our history, rape was a capital offense. You could be put to death for it. In 1978, the Supreme Court said it's disproportionate that, and with rape, unlike murder, the victim, albeit the victim's life has been ripped apart, nonetheless, the victim is still alive. And so therefore, the Supreme Court said death is an inappropriate sentence, an inappropriate penalty for the crime of rape. In the early 2000s, the Supreme Court ruled, and it was reversing itself from its prior decisions. It ruled that it's cruel and unusual to execute someone who's mentally disabled, or using the words of that, the terms of that decision, who's mentally retarded. So if somebody is labeled as mentally retarded, we cannot execute them. Likewise, the Supreme Court overruled some of its decisions dealing with juveniles, and in the early 2000s said it is unconstitutional to execute anyone who committed murder, which is the only capital offense left, who committed murder when they were a juvenile. So if you're under 18 when you commit a murder, you cannot be executed in the United States.